content provided on this podcast is for general informational purposes only. The views and opinions expressed by attorney Hannah Botkin-Doty and her guests are not a substitute for specific legal advice tailored to your particular situation. If you have legal questions or concerns regarding your individual case, please consult with a qualified legal professional in your area. Let's go ahead and get started. Save everybody their time. My name is attorney Hannah Botkin-Doty, and I am the sole proprietor of Hannah's Legal Help. I am a local attorney that has been practicing in and about the area of LGBTQIA plus related law for more than a decade. And so I wanted to extend an opportunity this evening for folks to have an understanding of where we are legally in the state of Ohio with LGBTQ plus rights, and get some questions answered that they feel they need to know, and to hopefully through that sharing make everybody feel a little bit more comfortable and a little less alone. I will say that anything I say tonight is my opinion. It's not specific legal advice that's predicated on your situation. If you do have a specific question, you can feel free to reach out to me on my website, hannahslegalhelp.com, or follow up with me after this presentation. So where we are in between a rock and a hard place. We are, on one hand, looking down the barrel of not only a conservative presidency, but a conservative legislature, a conservative Supreme Court, at our nation. And frankly, in Ohio, very similar. Our legislature and our courts are now almost entirely conservative minded, which means that they are not interested in socially liberated ideas regarding same-sex parents, regarding transgender individuals, regarding people of any other sort than what they believe to be true. So now is the time to start looking at your life and considering what can you do to protect yourself, protect your family, protect your children, protect your assets if the legal field starts to change. Tonight, we're going to cover what happens to marriage equality in this new era, what happens to legal parentage for children of the LGBT community, some real basic emergency planning or estate planning that you can do to emulate the same rights that comes with marriage. And then finally, we're going to touch on some transgender rights regarding name changes and gender corrections on birth certificates. So I have been practicing pre-Obergefell, our same-sex marriage decision, and post-Obergefell. So 2015, we had Jim Obergefell, an Ohioan, and about 18 other plaintiffs go up to the Supreme Court and ask to have their marriages confirmed as legal and to enshrine gay marriage as a constitutional right under the 14th Amendment, Due Process Clause, and Equal Protection Clause. Prior to same-sex marriage being legalized, you had different states marrying folks and different states not accepting that. And so the federal government finally came to the decision that same-sex marriage was and is a constitutional right and should be extended to same-sex unmarried couples and the children that they have. And as we know, marital rights in our country come with about 1,000 ancillary rights that are attached to the legal relationship of a spouse. And so we're going to talk today about what some of those rights are and what could happen if those rights went away. Since Obergefell was decided in 2015 in a very slim one-person majority, the state of Ohio has enshrined in its constitution, a same-sex marriage ban, explicitly stating that marriage is between one man and one woman. Now, that part of the Constitution at this point is overruled by the Obergefell decision, but some people pointing to Dobbs, which is the decision that the Supreme Court made that took away federally guaranteed abortion rights, overturning Roe, they point to that decision and say, hey, that's the same amendment. That's the 14th Amendment that it's based on, the same privacy rights, the same equal protection rights. So what if the Supreme Court goes and does Obergefell next? Um, I will tell you that I have an opinion that I reserve the right to change based on more information that allows me to have some hope that Obergefell will not go the same way that Roe did. And let me tell you why. First, in its decision in Dobbs, the court explicitly stated that this legal protection has no effect on other legal rights associated with the 14th Amendment and specifically named same-sex marriage in the majority opinion in Dobbs. So that's something. They're already thinking about it. They're already knowing people are going to equate this. Um, the second is that abortion, unlike marriage, is something that either has happened or you need access to. So it's very bureaucratically simple for a court to say no more as of this date. And in fact, in Dobbs, they didn't say no more abortions. They said let the states decide, which is what states were doing with same sex marriage. So you all are aware that after the Dobbs decision came down across the country, advocators were putting onto the ballot constitutional amendments that specifically enshrine abortion into our Constitution. In fact, Ohio had one and passed it. So, worst case scenario, if the courts were to try to overrule Obergefell and put it back to the states, there is a very vibrant community that could come around and enshrine that in our Constitution. Now, that's if you continue to trust the voters of Ohio, given the outcome of the recent election, but based on abortion and how overwhelmingly supported it was by people who normally wouldn't step out of their way to advocate, it does give me hope. The difference, however, as I was saying, between abortion and marriage is that abortion is something that has either happened or that you need access to. A marriage is a continuity. It is a relationship. And all those thousands of rights that exist by the government by virtue of that marriage would be affected if the Supreme Court said, well, I guess these marriages are grandfathered in and no more after this. And then somehow the government, in its actual function, would have to determine who is legally married and who isn't. Or if they say all marriages are void, which is even less likely, you'd have to go through the process of untangling the legally married folks and making sure that birth certificates were corrected and all the court cases that would come on custody and paternity, and it's a nightmare for the legal government. Another reason why I think that same-sex marriage is not necessarily on the imminent chopping block that we need to worry about is because as a whole, as a society, in this last election, we didn't see advertisement about same-sex marriage ruining, the American way or the American lifestyle. I think that enough people have a LGB brother, teacher, gym instructor, friend to understand that we are just like them. We're just trying to get through, raise our families, do the right thing. However, I believe that it is the trans community that needs our support and our help and is legally on the chopping block at this moment, because they are other enough to same-sex couples and to heterosexual people that it is easier to pick on them without repercussions. And by pick on them, I mean strip them of their worth and their rights. And so I think that as we look to what happens next, what's going to happen to marriage, what's going to happen with this new Supreme Court, this new government, I think that the best thing we can do is take things as they are, step forward on the path to do what we can to protect ourselves, our businesses, our families, while also understanding that unless you are a trans person, your life and your livelihood are not necessarily on the line as of yet. If you were married pre-Obergefell, and you had a child or there is a child in your life that came through of your marriage, then you need to ensure that your birth certificate and your marriage certificate are up to date. Specifically, that it contains the legal information and names of both legal parents. And we're going to talk about how marriage gives parental rights for just a little bit. So, if you'll bear with me, the United States gets all of our laws from merry old England, right? And there is a bureaucratic convenience that is enshrined in every state's law. and it's called the marital presumption, and Ohio has it. And it says, in essence, if a man and woman are married, and understand these are very gendered terms that are still in our state law, if a man and woman are married and the woman has a child, it is the husband's child because all women are faithful. That's the presumption. The marital presumption allows people to have kids, sign a birth certificate and say, yep, that's my kid, and then all of those legal rights flow. This is why you don't see opposite sex couples running to do adoptions or custody or parentage determinations, because it's impacted and influenced by the inherent marital status that legally gives parental rights. Now, of course, it's a presumption, and that presumption can be rebutted, namely with DNA tests or whatever else we have to say that's you're not the legal parent. Post Obergefell, I would take clients from who had had marriages secured in other jurisdictions like Vermont or New York or wherever, and had had children, and only one parent was on the birth certificate, the one that had given birth usually. And then we equated essentially the what we call surrogacy statutes here in Ohio, because straight people have been having children through surrogacy forever. And the surrogacy statutes say if the people are married, the spouse who's not giving birth gives their consent, and there's a medical intermediary, a doctor or someone to facilitate the insemination or to be on consult or in support, then any child born by virtue of that insemination is considered a child of that spouse. And so what we did as attorneys is take those people who needed their birth certificates corrected to the juvenile court, which is one of two courts that handles paternity. In the juvenile court, we said, Your Honor, the court said that Obergefell gives us equal protection. Obergefell holds our marriages out to be the same as any other heterosexual marriage. And we followed the surrogacy statute such that there are no other legal parents. By virtue of us doing everything correctly, you make an affirmative finding called a second parent determination saying this other person is the legal parent and there is no one else. And so we would do that, and we would update the birth certificate, and everyone would go about their way. After about a year of doing that, the juvenile court started saying, you know what? Don't come here. If you're on the birth certificate, unless there's somebody missing, if you're already on the birth certificate and you're married, there's no need for you to be here. Nobody's saying you're not the parent. You are the parent. And until or unless somebody comes to challenge that, you're just taking up our time, and we're very busy. We're not going to give you some affirmative judgment anymore. And so we said, okay, well, there's two courts that do paternity. Let's go to the probate court, who does paternity through adoption and updates birth certificates. And so we'll go to the adoption court and say, hey, we have this couple. They had a child. We want to make sure that everything is not only clear on the birth certificate, but also in a court order. Can we please file for an adoption? Despite the fact that we shouldn't have to do this because of the home inspection and the background check and all these things. And we're like, but we just want that legal signature. And the adoption court said, no, the only way we can the only time we're going to hear a married couple is through a step parent adoption where the person wasn't married at the time of the child's birth. And they go through that portion to get the birth certificate updated. If the birth certificate's correct, that's all we could do for you. Go away. So for everyone out there who's like, what do we need to do to secure our parental rights? At this moment, you have done everything you could if you were married and had a child using the structures of the government. What can you do left? What else is left to do? The portion that I'm going to try and focus on is estate and emergency planning, because this is what we did pre-Obergefell to try and cobble together the rights that people would have upon marriage. So things like financial power of attorney. Someone has the right to have access to your accounts if something happens to you or if you need them to pay a bill. Healthcare power of attorney, who's in charge of making healthcare decisions. And sometimes just as importantly, who is absolutely not in charge of making decisions on your behalf. A nomination of guardian. If something happens where you are disabled and unable to provide care for yourself, who's in charge of making sure what doctor you see? Who's in charge of knowing where you live? And then also nomination of guardian for minor children. If something happens to you, who's in charge of your kids? Who's their legal parent? And if it's your spouse, obviously, who's the backup in case your spouse and you are on the Titanic together for some reason? And I've even had people put backups to backups. It depends how risk averse you are. And in those things as well, but you can also say, and this person is especially not to be considered. Um, and it allows you to create those legal documents that are then signed and notarized or witnessed if it's a last will and testament to say, even if this legal protection of marriage is gone, these documents will speak for me and will inform a court, a funeral director, a bank, a school, who is in charge and who is not, and what information they're allowed to have access to, and what rights they have. And so these documents come together to create that underlying scaffolding of protection that, regardless of what happens to that legal relationship, these underlying orders, these underlying intents are already created. I will tell you that if you do not create these documents, the state has its own way of determining who is in charge and who your heirs at law are and who your next of kin are. In most, in fact, all cases, your next of kin, if you're married, is your spouse. And then it goes down to your children and then your parents and then your siblings and on and on and on and out until the court determines how to connect you to these people, whether it's who you're leaving stuff to in an estate or who's in charge as a guardian. And if you don't have anybody or if you don't have anything, that third party, that judge or that person making the determination will only be going on what they know of you. So this level of intent is essentially important to enshrine in these documents, especially now. Also, if you already have these documents, but they're out of date, they're very easy to update. As I say to all my clients, these are Word documents that live in my cloud. If you need to make a change, you surely can. And if you do make a change, the previous documents are revoked typically as part of the very first paragraph. Um, Another option that some people are considering are trust, where you create this separate entity that you just put all of your assets into by virtue of beneficiary status. So, for example, instead of saying my bank account to my wife or to my husband, it would say to the family trust. And then that trust catches everything and then is run by you while you're alive or your trustees after you pass. It's another way to sort of separate out your assets and contain them in a way that the probate court doesn't have to be involved in. Anything that has a title on it, that has your name on it, is what we call a titled asset. So your car, your house, your bank account, your dog, anything that we know is yours, you can put a beneficiary on. If you own your home, then a TOD or a transfer on death says, upon my death to this person. Now you can buy and sell that house while you're alive, but if anything happens to you, instead of that person having to go to the probate court and prove who they are and work through filing fees and attorneys and court time, they could automatically have the title to the home. The same for a car. If you own the car, you can go to the BMV's website and they have a transfer on death affidavit ready for you to fill in. If you go to your bank and you sit down with your teller, they have individualized pay on death beneficiary status. And so, again, if you don't want to put someone on your account or on the title of the car or on the house, you can still name them as the automatic beneficiary to avoid probate. Or if you have a trust, you can name the trust. And the trust just collects all these assets and then they're distributed in the way that you say, just like you would in a will. A lot of people, when they think about beneficiaries, they're like, oh, yeah, like life insurance or retirement. But there are so many other ways that you can take small steps now to prepare so that on the back end, there's not as much work. And that's really the bucket when it comes to estate planning or emergency planning. Either you do the work now and it's much easier and clearer on the back end, or you don't do anything now. And on the back end, there's lots to do for the people that are trying to help you or mourning you or whatever. So it's always a good idea, regardless of your status, to have some emergency documents. Some of the really primary ones that affect the same-sex community the most or the LGBTQ plus community the most is medical care and funeral arrangements. So medical care, who's able to see your diagnoses? Who's able to have a HIPAA waiver? Who's the one to make a decision about what doctor you see or what procedure you have if you're not there to make it for yourself? Who is absolutely excluded from that decision? Who should not be consulted? And then with funeral arrangements, if you are non-gender conforming, who's going to put you in the correct clothes if you're having a funeral? Who's going to make sure that your obituary is not an affront to who you are? And these are things, especially for the trans community, that I think people need to take the time to think about because it's 2 pages and a notary stamp for a funeral arrangements document. But it's so important and essential when you don't have, and when you don't have one, it can be. Finally, I want to talk about the financial power of attorney. The kinds of financial power of attorneys that are the best for emergency planning are what we call general, durable financial powers of attorney. General means it encompasses every right that you can give to another person that the state of Ohio says you can. Some of these you might not need, but they're all out there just in case the person in an emergency needs to do something. This is different than like if I said, hey, here's a power of attorney. I need you to go buy me a car, or you need you to go buy me a house. It's very specific. Durable is a power of attorney that outlasts your incompetence. So if you're the person making the power of attorney and you're competent when you do it, and you appoint an agent to represent you, if it's not a durable power of attorney, if you're incompetent, so is your agent. Because the power of attorney is durable, if you become incompetent, it has no effect on your agent's status to act. Like I said, if I had made as a specific power of attorney saying I need you to go buy me a car, and then something happened where I was incompetent and not able to drive, then I wouldn't want that person to do that. But in an emergency situation, you don't know what the situation might be. And that emergency planning and that durability of the financial power of attorney is going to allow them to continue to act. Let's say you do all this great stuff and you go through the time and effort of making an estate plan, making an emergency plan, signing it, getting it done. You need to make sure that the people who are named in these documents to act on your behalf are able to access these documents. Whenever I do this, I always scan the signed copies and email them and say, send this to your power of attorney. So they have it in an email, they have it in a cloud, and then let them know where the original is. The number of times where people have kept their estate planning documents in a fire safe and told no one the combination. Or I've had people come to my office with older paper and I'm like, what is that smell? And they're like, oh, we keep it in the freezer because a firefighter told us it was the last thing to burn. Regardless of where you store your private documents, ensure that they are distributed to the people that are going to need them because these documents should all say a copy will operate as the original. So the person doesn't have to go through and find the original document to go to the bank to get the thing. Also, you can proactively let your organizations know that these documents exist and who should be coming to make these decisions. For example, a healthcare power of attorney can be uploaded to your MyChart. A copy of your financial power of attorney can be kept in a file at the bank, or they can add that to the name on your account. You can take proactive steps to ensure that all the groundwork is laid. So if there is an emergency, there's no confusion as to what your plan and your intent was. When it comes to next steps for your family, this is something that you need to really take in and assess. Given the level of risk that you're in, depending on your community, depending on your job, depending on your risk tolerance, you may make a different decision than somebody else. But understanding that this situation that we're in legally and socially and politically is going to continue to evolve, the most important thing you can do is take care of one another and ensure that you are there for folks. Because even just yesterday, the Supreme Court of the state of Ohio issued a decision for a woman whose last name is Adelaide, and she had asked to have her gender marker changed on her birth certificate. And the Supreme Court not only said no, they said we don't even have the right to decide that. The state of Ohio has said you can correct a birth certificate if the information at the time of the birth was wrong, but you can't amend a birth certificate. There's no legal status in our law saying that you can. And so the Supreme Court essentially just punted it to the legislature saying, hey, super majority conservative legislature, why don't you make a nice path for transgender folks to correct their birth certificates so that all of their documents are accurate and the same? Or individual county court probate judges, you get to make a case-by-case determination about whether or not you are going to amend these birth certificates to accurately reflect the gender of the person. And this is something I'm quite passionate about because I think if you are a person who is transgender and wants to have your gender marker updated, whether it's your birth certificate or your driver's license, if you get pulled into a situation where you have to reveal one of those, it is compelling your speech. So it's a free speech violation because but for this information being on those documents, the officer you're across from at a speed stop or the person at a hospital would not know your transgender status. And so these consistently come before the courts, and these consistently get differing opinions depending on which court you're in. And finally, the Supreme Court of Ohio has just completely said it's not our problem. We don't even have the right to hear this. The legislature needs to make a change. So when I say things will continue to evolve, they are evolving. And it is essential that we as a community come together and protect each other and ensure that everyone's rights are enshrined and not fail to help one another due to apathy, due to exhaustion, due to a fear of just trying to keep yourself safe. I feel that it's very important that we as a community stand up for the folks that are currently under attack. And I, as an attorney, as a lesbian, as a mom, as a wife, want to be a resource, if I can, to as many folks as I can. But again, I thank you, and I hope you all have a great evening.